All right. Good afternoon, everyone. Again, my apologies for the delay. We are again welcome to our November in the boardroom with attorney Andy Phillips and Attolles Law, where we are going to hold part two of our in the boardroom, where we're going to talk about county board rules. So with that, Andy and Malia, I'm just going to turn it right over to you guys. I suppose I should mention though that if you have questions, the Q&A and chat feature are live on this Zoom. So if you have any questions throughout the presentation, please use the Q&A and the chat feature. And we will be monitoring that throughout the next hour. So, all right, with that, Andy, Malia, go ahead.
Thank you, Sarah, and good afternoon, everybody. Thanks for putting up with our technical difficulties while we figured that out. I'm Andy. This is Malia. I'm a lot closer to Malia than she really wanted me to be today. And I think that's one of the things that you're very thankful for as we have this Thanksgiving week. Today, we're going to regroup and talk about county board rules again. As mentioned in the last webinar in October, in September, the Counties Association released a template set of board rules. And that template set of board rules came about as a project because we had so many counties that were reaching out to us and asking about board rule for this, board rule for that. Do we have a template set of board rules? And we said, you know what, that's a great point. Why don't we just create a template set of board rules that essentially gathers all of the information and feedback that we've received from counties over the years and put together the decision points and the analysis and the language and the information that we think belongs in a set of board rules. And so as we think about concepts surrounding board rules, I want to make sure that we emphasize this point. This is not one size fits all. There are things that you may want to address in your board rules that we don't have in this template. And likewise, there might be things in this template that you don't want addressed, and that's okay. Essentially, use the template as a discussion starter. And so it should be a process that you go through as a board, working with administration, working with other members of your team to figure out what really belongs in our board rules. I'm not going to reiterate what we talked about last time. That means we can skip the first three sections of the template and get right to what I think is the meat of the board rules, and that is procedural issues that confront the Board of Supervisors. So before I do that, let me turn to Malia, and I can physically turn to her this time, and say anything that you wanted to add before we begin the discussion.
No, Andy, but I apologize for not taking a mint after drinking my cup of coffee. I did not know you would be this close.
I didn't shower this morning, so actually you've got me beat on that one. So let's go right down to, that's way too much information for anybody on this webinar to process. So let's go right down into section 4 of the board rules where we get into the procedural rules. I'll get there eventually, bear with me. Section 4, rules of procedure. And so in the first three sections, we defined the qualifications for officers. We defined how officers take their seat. We defined what the organizational meeting, annual meeting, that process looks like. We defined our committee structure. And if you remember, we said that the committee structure is probably best explained in an appendix or a supplement to the board rules so that you can modify that from time to time without reopening your entire board rules. And now we're on section 4 of the board rules, which is the rules of procedure. We start with 4.01, parliamentary authority. This is important because a foundational element of the board rules is going to be what are the rules of procedure that govern how it is that we conduct our meetings, whether it be a board meeting, committee meeting, whatever. What are the foundational rules? And the foundational rules are Robert's Rules of Procedure. So we want to make sure that we have Robert's Rules of Procedure, the newly revised latest edition, identified in the board rules as the parliamentary rules that govern our meetings. In the absence of that, there are questions surrounding what rules of parliamentary procedure actually govern proceedings. And so we don't want to have that question left open, and we want to make sure that we adopt Robert's Rules of Order, newly revised, latest edition, as our parliamentary authority. The second sentence of this section 4.01 is really important too. Who's the parliamentarian for purposes of our meeting? And I think there are misconceptions out there about what a parliamentarian is or does. A parliamentarian does not run a meeting. A presiding officer under Robert's Rules runs a meeting. In our circumstance, we have a board chair or a committee chair that runs a meeting. Who answers questions of parliamentary procedure? Who answers and rules upon questions or points of order. It's the chair, okay? So the parliamentarian is not the one running the meeting, is not making an official determination on questions of procedure or questions of order. The parliamentarian, however, is somebody, and this is right in Robert's Rules of Order, it's somebody who should be consulted by the chair when these questions of parliamentary procedure or points of order or other issues arise during the course of a meeting. And so it's important within our board rules to designate who is going to be the parliamentarian for a particular meeting. In this circumstance, we have it can be the corporation counsel, it can be the county clerk, it can be other. I happen to think that the corporation counsel is best suited for this role. I happen to think that the corporation counsel is trained in the analysis of rules of procedure and how to apply those rules of procedure to a given circumstance. But other counties may disagree, and that's just fine. I'll ask Malia to chime in here because she was a corporation counsel. She served as parliamentarian for county board meetings. Your thoughts on that?
Absolutely. As the corporation counsel, I was seated very close to the county board chair, particularly for that reason, just logistically and physically in the room. So when one of the board members would call for a point of order, the chair could address me to address that point of order. Now, my recommendation was never required to be followed by the chair, but most of the time the chair would follow that. One of the things I would suggest, however, if there's a complex procedural issue that's going to be addressed at any meeting, talking to the corporation counsel ahead of time about the procedural posture and how to best effectuate certain moves through the rules of order and through Robert's Rules of Order, that can really help hasten the issue when it comes to the actual meeting itself. So having those conversations with your parliamentarian ahead of time are very good and very important.
All right, great. So then we have section 402, Committee of the Whole. And this is a concept that is foreign to some counties and very, very routine for other counties. We often see county boards convene as a committee of the whole for purposes of doing certain things. And I often get asked the question, what is the committee of the whole and how do we do this? And if you look at Robert's Rules, the committee of the whole is an opportunity for a deliberative assembly, in this case, a county board, to convene as a committee of the entire county board for purposes of engaging in discussion or other items of business that don't necessarily lend themselves to a full county board meeting. What do I mean by that? If you're going to, for example, engage in strategic planning, that's not going to follow a typical order of business that we would see on a county board agenda. In other words, there's not going to be a resolution introduced. There's not going to be a motion made and seconded and then debate and discussion surrounding the particular resolution or item of business with potential amendments to that, and then you get to a point where you eventually vote on it. If you're going to engage in strategic planning, you want ideas that are out there on the floor, and you can discuss those ideas, and then you can speak to this whole concept of whether that idea needs to be put into a particular strategic plan that eventually will be introduced at the county board level for adoption. And so you convene as a committee of the whole to engage in that loose discussion surrounding that particular item of business, in our example, the strategic plan. So the committee of the whole is a useful opportunity for the board to go through an item of business that doesn't lend itself to the typical rules of procedure that we see as the full county board. Now, the committee of the whole still has to comply with the open meetings law. That's very important. Okay, so we think of the committee of the whole as being just like any other committee of the county board. We have to notice the agenda. We have to provide public notice. We have to have the public, assuming it's open session, the public has a right to attend that meeting. But the committee of the whole is, at least in our opinion, a useful process in certain limited circumstances. I don't think it has to be every month. I think it's something that can happen from time to time as needed, but recognition of this committee of the whole concept within the board rules is an important concept. And Malia, feel free to jump in anytime here. I have a tendency to talk over other people. I think everybody knows that, so feel free to jump in.
I'm also used to talking quite a bit, and so it's refreshing not to be the one doing all of the talking most of the time. But one of the things that you can also do with a committee of the whole is place that as an agenda item within a normal county board meeting. Because then when you convene in committee of the whole in the middle of a county board meeting, especially if it's noticed, it loosens the rules, those formality rules that generally govern legislative deliberative bodies. So you can have more of that back and forth discussion. Sometimes, especially county boards in areas where you've got a lot of different interested parties on a particular topic, you might bring in a presenter to come in and present things, and you want the county board members to be able to actively have a back and forth conversation with the presenter. That might be an appropriate time to have a committee of the whole noticed on the agenda. Or when you're setting new county board priorities and you want it to be a robust discussion without folks having to be recognized by the chair, you can have that also in the committee of the whole. So they can be useful not only as a separate meeting, but also as a little meeting within the meeting.
Exactly. 4.03 remote attendance at meetings, and the counties are all over the board on this. Some counties want to really encourage remote attendance at meetings, and other counties have flat out said, we don't want our supervisors being at our board meetings, we don't want committee members being at our meetings remotely, we want them there in person. That's a policy decision. You can make that decision as a board, but understand too that under Robert's rules, we do not allow remote attendance at meetings unless specifically authorized. Okay, and it's not just authorization of, hey, it's a good idea, you can do this. It's authorization within the board rules. So if we're going to allow remote attendance at meetings, you have to have something in your board rules allowing that remote attendance. And if you're going to allow it, let's define the boundaries, the rules where somebody can attend remotely. I don't think anybody thinks it's a good idea just to allow anybody to attend remotely at any time with no rules. I think there have to be rules surrounding remote attendance. And so where you see in these template board rules, italicized text, this represents a decision that you as the board need to make related to what are those rules. And so we've got in here some considerations as it relates to remote attendance. For example, if we have somebody who's there video conferencing in, for example, on Zoom, and I think we've all seen today, Exhibit A, why Zoom might be challenging in certain circumstances, and for that matter, Teams or Google Meet or whatever platform you use, technology isn't 100% reliable, so make sure that we have good technology. But beyond that, if somebody is attending by video, are we going to have a rule that says they have to have their camera on at all times? I don't think that's a bad rule. It's not a bad rule because if they were there in person, they would be in the meeting at all times unless otherwise excused by the board chair or the committee chair. The other thing I think is important is that it's awfully hard to run a meeting by remote communication if you've got people in a room in a particular spot or location that are also in that meeting. In other words, I think it's awfully hard to be the chair of the board or the chair of a committee and run that meeting remotely. And so you may want to consider a rule in place that says you don't get to be chair and attend by remote communication. Go ahead, Malia.
Another thing when it comes to remote appearances, when you have a closed session contemplated on the agenda, or if the need arises in a meeting to go into closed session, making sure your rules of order set out the expectation that anyone appearing remotely during that closed session needs to be in a private and confidential space is important for those closed sessions.
Oh, it's incredibly important. And let me pause there. The Attorney General actually came out with some good guidelines on remote meetings and open meetings law compliance. Just because it's remote doesn't mean that we don't have to comply with the open meetings law. The open meetings law was drafted, by the way, long before remote meetings were even a speckle in anybody's eye. So understand that we are taking an old law and putting new technology on that old law. Nonetheless, there is a way to comply with the open meetings law. And so I would really encourage people to take a look at the Attorney General's guidance on open meetings law concerns. I know WCA has produced an awful lot of material on this as well. We worked extensively with WCA back in the COVID era in dealing with remote communication and remote meetings and those sorts of issues. So if you want resources on what types of practical considerations and rules can be developed surrounding remote attendance, feel free to call WCA, go to their website, they've got materials. The final thing I will note is that I think that remote attendance at meetings is one of those evolving things, so that we may think it's a good idea now, but then something happens and down the line we think, oh boy, I wish we had a rule in place to address that. You may want to consider delegating the ability to define the rules surrounding participation by remote communication to a committee of the county board. That way, that committee can meet and develop those practical considerations and rules surrounding remote attendance without having to reopen the entire set of the board rules and get a 2/3 vote to amend those board rules. I say 2/3 vote, you don't have to have a 2/3 vote to amend the board rules, but you'll see later on as we go through the template that there is that supermajority requirement to amend the board rules. So again, remote communication, it can be incredibly beneficial. It allows for greater participation, but it's important that we define the rules surrounding the utilization of this technology in order to participate in board meetings and committee meetings. All right, so moving on through 4.04. Here we've got the defined order of business as it relates to county board meetings. I think it's a great idea, and in fact, Robert's Rules has an order of business that's typical for any meeting. The reason that Robert's Rules contains that is so that there's no confusion about what an agenda looks like. Same principle applies here. There should be no confusion about what a board agenda looks like in your county. There ought to be regularity. The public ought to have an understanding of what a county board meeting looks like. There's no magic to the 1 through 16 that we've got here. It is loosely based on the order of business that's contained within Robert's Rules. But of course, Robert's Rules wasn't written with governmental bodies in mind. And so we have modified what's contained in Robert's Rules in order to comply with what we think ought to occur during a county board meeting. But again, there's no magic to this. If you want to do the Pledge of Allegiance before the roll call, that's fine. There's nothing in the law that says you have to do the Pledge of Allegiance, for example. So you can feel free to modify this order of business as much as you'd like. Now, one thing that you'll see missing here, and that's because I've heard comments both ways on this from counties. You don't see in there a consent agenda. And a consent agenda is a really cool opportunity under Robert's Rules to take care of a lot of items of routine business with one single motion. For example, if you have to approve claims or approve vouchers or disallow claims or so on, you can do all of that under a consent agenda without taking up every single item that is contained within that consent agenda. So if you have 15 different vouchers to approve, you can have a consent agenda item and say approve 15 vouchers submitted, and then in your county board packet include those 15 vouchers that fall under the consent agenda item for approval. Now, any member of the board has the ability to pull an item from the consent agenda for individual consideration. That's fine. But again, we don't have the consent agenda on here in the template rules because I've heard some counties say they love it and other counties say that they don't want to do it. Talk with your corporation counsel, talk with your county clerk about how consent agenda works and whether it makes sense for your county. I don't know, Malia, did you use a consent agenda in Polk County?
We did use a consent agenda for routine administrative accepting of grants, gifts for the county, things that generally would be considered non-controversial of minimal significant public interest. But we would have things placed on the consent agenda from time to time where board members would ask to remove because they had a particular issue with one of the matters on the consent agenda, but we found it was helpful.
Yeah, and so I think again, the effort here is to design the board rules and run our meetings as efficiently as possible. Nobody likes sitting in 4.5-hour long county board meetings. Nobody. I mean, so is there a way that we can promote greater efficiency in the board meetings? Yeah, we can do that through having an order of business in our board rules. We can do that by adopting rules of procedure. A consent agenda is another item that we can consider to create more efficient and quicker meetings, so to speak. All right, and then we have here, and this is important as well. There may be a reason that we want to modify the order of business for a particular meeting. We may want to, for example, take a report and put it toward the top of a meeting because we know somebody is going to have to leave the meeting a half hour into the meeting, and we want to make sure that the report is heard. So here we have in the board rules that the board chair can always modify the order of business, and as well as by majority vote of the board itself can modify that order of business. Now, what you don't see here, or at least it's in brackets and it's italicized, is approve agenda. There is nothing in the law that says, it's not in parliamentary procedure either, that the board has to approve an agenda during the meeting. So why is that on there? Why is that done? Why do we see so many counties have approved agenda on the agenda itself? And I think there are various thoughts on that. One of it is just historically and traditionally, they've done it that way. But the second is to make sure that the public is provided notice of the order in which things will be taken up as an item of business. We want to know that if we have items 1 through 16, that we are going to proceed 1 through 16 on down through the agenda. It's an opportunity at that point in the agenda where we approve the agenda for somebody to say, hey, look, we've got somebody making a report on item 12A that isn't going to be here in a half hour. Can we move item 12A up to item number 5A or 6, whatever the case may be? That's the opportunity for the board to weigh in on that. So I think those are the couple of the reasons that we typically see that on the agenda for county board meetings. But again, it's not legally required. The published agenda is the published agenda, and absent any modification, you're going to proceed through the agenda. Thoughts on that, Leanne?
I would just make sure that if you're going to be moving things around, and most agendas should have this anyway, when you're publishing an agenda for public notice purposes, is to indicate that just because the agenda appears in a particular way with certain things following others, that it could be moved around so people don't say, well, I didn't log in to listen to the meeting, or I didn't show up to hear the meeting. Only public hearings that are required to start at a particular time are going to likely start at that particular time, but anything else can be moved so that you're covering yourself, so people have noticed that they might be moved into different orders.
Very good point. Public comment. I'm going to address this later on when we get to the rules of procedure, but understand public comment is not required to be on every board agenda. It's not required to be on a committee agenda. It's up to you to decide when public comment is appropriate. There's nothing in the law that requires public comment. So we italicize that to emphasize the fact that you have a lot of flexibility in defining how public comment occurs. Committee meetings, same principles. We have the items or order of business for all committee meetings. It's important that this be contained within the board rules as well. And so again, same principles apply for committee meetings. Approval of minutes. There's no requirement that the minutes be read. I've seen many counties where they actually out loud read the minutes from the previous meeting. That doesn't need to happen. If we are going to distribute a draft copy of the minutes as a proposal for the minutes from the prior meeting in our board packets, I don't know why we would read those things out loud. We should have supervisors reading them to themselves, and if they have additions, corrections, or deletions, they make that motion at the appropriate time. Same with consideration of resolutions. No requirement that they be read. Some counties still read their resolutions. There's no requirement that they be read. Here's the other thing too, that you may want to consider putting in your board rules, and I've seen this in various counties as well, is that a resolution is typically forwarded to the county board with the support of a committee. If it's already been through committee and received the support of the committee, that means we have at least 2 members of the county board that support that particular resolution. So is there at that point really any need for a motion and a second to adopt the resolution? Not necessarily. When you think about the purpose of a motion and a second, it's to show that somebody wants an item of business before a body, and that somebody supports that item of business being before the body. That's in Robert's rules. So if we already have 2 members of the board who sit on the committee forwarding a resolution to the board for adoption with a recommendation of adoption, why do we need a separate motion? The answer is we don't. So you may want to consider within your board rules putting a provision in there that a resolution that is advanced by a committee doesn't require a motion or a second, that it is automatically before the board with a recommendation of adoption from the committee. So you can do that. Again, not required, but that may be another way to try to efficiently get through items of business. Did you do that in Polk County, by the way?
We had 2, and it evolved over time, but we had a 2-tiered process where, depending upon whether or not the committee forwarded the resolution on with a positive recommendation versus a committee forwarding a resolution on with a neutral recommendation, which was frowned upon because the work should be done at the committee to ferret out whether or not this resolution is something that should be put forward. So deferring sort of the general conversation about whether a policy idea in a resolution is good or bad to the full county board rather than hashing it out at the committee level is, again, not ideal, but we had a 2-tiered system.
Yeah, so it's up to you on how you want to define that, and you can do it a variety of ways. Conley had a great question. When we're talking about the order of business, is that only moved around by the chair of the board or the committee, or does the board or committee itself have to approve movement of items. That's up to you. I mean, ultimately, it depends on who creates the agenda, who has the ability to modify that agenda. And remember that the body can always overrule what the chair does. And so you may want to create a system where with the approval of the body, the chair can move items on the agenda. And again, when we talk about efficient meetings, that's a key for the chair to say, is there any objection to me moving reports item 12 up to item 6 so that we can allow the speaker to get out of here in 30 minutes? Any objection? Hearing none, the agenda is modified. There you have the approval of the body because nobody objected. If somebody objected, then it goes to a vote, and the majority of the supervisors then would have to approve of that movement. So it's really up to you, Conley, as to how you define that circumstance. Personal electronic devices. This is something that is incredibly interesting to all of the lawyers and corporation counsel out there. And here's why. We want everybody to put their mobile devices into their car and leave them there for the duration of the meeting. That's the lawyer rule. We know that that doesn't always happen, okay? So I get it, but what we want is we want a meeting without interruption from personal devices. That doesn't mean the county issued iPads, laptops, whatever the case may be for official county business, because again, I think the electronic distribution of meeting materials is awesome. And I think if we have county issued devices to access those materials, great, but personal devices, leave them in the car, because we will inevitably see people during a county board meeting or a committee meeting get about 15 minutes in, then all of a sudden they start doing this. What is it that they're talking about? We have no idea. Are they talking about the item of business that's before the body? Maybe. If they are, we created a public records issue, you bet. If they are, we created an open meetings issue, you bet we have. And so as lawyers, we get so nervous when we start seeing those personal devices come out during meetings. So instead of relying upon the goodwill of the meeting participants, let's put it right in our board rules. That's not allowed. You can't do that. Let's have those folks leave their personal devices in the car when they attend the meetings. Same with the public. I mean, the public, there's nothing more distracting than having somebody's mobile phone go off with a ringtone in the middle of somebody's debate on a particular motion or resolution. That's annoying as heck. So let's put it right in our board rules. Then anybody attending that meeting has to have their personal electronic devices either in silence mode or completely off. Thoughts on that, Malia?
I would agree, and your comment here about not prohibiting recording is also appropriate. So saying you can't have a phone in the room or have it on as long as it's silent, I think you've hit it.
Yeah, and I mean, the open meetings law says that anybody can record a meeting, so we can't stop them from recording the meeting. We can't stop them from interrupting our meeting, and that's the point. All right, recognition, debate, and voting at county board meetings. And this really depends upon the county and the system that you have. There are a lot of counties that have electronic voting devices, and so recognition happens by pressing a button and then their name lighting up in some sort of screen showing that they're in queue as wanting to speak on a particular matter. In other counties, they don't have electronic voting devices, and so they raise their hand or they do something in order to get the chair's attention to be recognized. In Robert's rules, it just says that a member is to stand, is to rise and request recognition and the opportunity to speak. But we don't really have that here. That's not a system that I've ever seen followed in Wisconsin county government. So really what you ought to do is define how recognition occurs in your county, depending upon, again, the technology that you utilize for doing that sort of thing. Debate, you get to define the limits to debate. Right? In Robert's rules, remember, you get to speak twice in 10 minutes each time. Do we really want to allow somebody to speak for 20 minutes total on any particular issue? Maybe that may be what we want to do, or we may want to shorten that time. You have the ability in these county board rules to shorten that time. And so again, you define the rules of debate. Anything you want to add on recognition or debate before I move on, Leanne?
Well, one of the things, tying this back to the parliamentary procedure and your parliamentarian, oftentimes folks will come up to the parliamentarian, usually the corp counsel, after the meeting and say, well, you know, Johnny spoke 4 times and I didn't get to speak once, and then everybody voted. And that doesn't seem fair, and that didn't comply with Robert's rules. And so if there are issues during the meeting, members need to ask for a point of order because they can't count on a parliamentarian to address an issue that they have not yet been asked. Same for the chair. So just knowing that something that's happening might violate some of these rules isn't enough for the chair and the parliamentarian to step in. Most times you need to call that point of order.
So what is the procedural mechanism to raise a point of order after a meeting is ended?
There is none.
Right. Once the meeting is done, it's done. And if everybody said everything went okay, it's okay. So to Malia's point, raise that point of order when it happens. That's very important. Also in sub B here under debate, you see a sprinkling of rules surrounding debate. For example, you see comments need to be directed to the board chair, not to any individual board member, staff, or member of the public. We always speak through the board chair. That's in Robert's rules. And I think it's important to put it here in these board rules. Comments have to be germane to the business currently pending before the board. We can't have members of the board running off on tangents that are unrelated to the resolution or issue before the board. And this is important too. Board members maintain and exercise proper decorum at all times when discussing any matter before the board. It's really important that we portray to the public that we know what we're doing and that we're good at what it is that we do as a county board. We want them to have faith in the business of our county. And we do that by displaying an air of formality. And I always say this, I say, the more formal we conduct ourselves, the more professional we conduct ourselves, the more faith the public is going to have in what it is that we do. And so we want to exercise proper decorum. Now, proper decorum is a term of art. There's no precise definition to proper decorum. You have the opportunity to define that. And I've worked with several counties in further elaborating on what we consider proper decorum to be. And so whatever it is that you decide proper decorum is in your county, I would really suggest you put that in your board rules so that everybody has an understanding of the expectations when you enter that meeting room. And that's really what it's about, is expectations. And when you do not meet those expectations, we have it clear in black and white that we have the ability to take some sort of action to make sure that you either conform to the rules of decorum that we've established, or we're going to ask you to leave the meeting. Thoughts on that, Malia?
Well, I would also suggest that if things start to devolve on a topic, calling a point of order by one of the members, addressing that issue of decorum so that there can be sort of a recognition. But the other thing is, if people are happy with the back and forth and not going through the chair and sort of the relaxed, casual formality rules, maybe that particular topic is something that might be appropriate for a committee of the whole.
Agreed. Voting, we want to have a voting process. Again, many counties use an electronic voting system, and so we want to specify in the board rules that we're going to use that electronic voting system. Otherwise, if you look at Robert's rules, there are any number of different methods of voting, and the chair really has a lot of discretion to determine what method to use, unless somebody raises the point that they want a vote taken in a particular manner, in which case they can demand that the vote be taken in a particular manner. It's easier to put something like this into the board rules. Abstention. This is a topic that I've discussed with a lot of counties too, is that somebody says, does somebody have to give a reason for abstaining? The answer is no. There's no legal reason that you can demand somebody provide you a reason for abstaining. There's also no requirement that somebody vote yes or no. They can abstain. That's an exercise of their First Amendment privilege in voting, is abstention. And so but this runs contrary to what I view to be representative democracy and the principles underlying representative democracy. And that is, I think people should have to make tough decisions. People should have to engage in tough discussions. People should have to earn their keep, so to speak, as an elected person representing constituents. And so I always like to see people vote. We can't have a rule on the books that says you can't abstain, but I would really encourage folks to vote. And I think that ought to be an underlying principle in every county. That said, there is good reason for people to abstain from time to time. For example, if we have an ethics issue or a conflict of interest issue where somebody's like, I do not want to run contrary to what Wisconsin law requires of me, so I am not going to vote on this issue, then they're going to abstain. And hopefully they're doing it on the advice of corporation counsel. And if they're going to abstain in that fashion, I would like it in the record, and I think corporation counsel would too, would like it in the record as to why they are abstaining, just to make clear exactly what happened with abstention. So again, I think we ought to have a process in the board rules to ask the question, why are you abstaining? Thoughts on that, Maria?
Certainly, a couple of things come to mind. When there is a voice vote, and let's say it is clear that one side won, just being silent and not saying aye on either side is not an abstention. And that can be confusing for some new county board supervisors who think, well, if I didn't actually voice a vote, but didn't get permission to abstain ahead of time, and then, you know, they on their social media page said, well, I didn't vote one way or the other on that, I remained silent. So making sure that when there's a voice vote, knowing that if you don't have anything on the record about a particular supervisor abstaining, they're going to be considered to have voted in that particular meeting. And that's especially true at the committee meeting. Also, an abstention, even if granted, if a particular vote statutorily or because of the rules requires a certain percentage of the entire body, not just the body there, not just the body that are voting, that would count in the negative by abstaining in those circumstances.
Conley raised another question. The way the rule is written, is it required that each abstain must explain why during the vote? I mean, yeah, theoretically, that's what happens, but you can't force somebody to explain if push comes to shove. So I don't necessarily like having the black and white rule that an explanation is required. At the same time, I think we encourage an explanation as to why the abstention is there, because if it is indeed because of a conflict of interest or ethical reason, we want to make sure the record reflects the reason for that abstention. E is important too. At the committee level, we don't have the rules of formality that typically apply in a county board proceeding, and so we want to make sure that we take advantage of Robert's Rules, Chapter 49, Section 21, that allows us to be informal at the committee level. Public decorum and comments, and I'm not going to spend a lot of time going through this in the particulars on this, because all of this is really up to the county as to how the rules are surrounding public attendance at the meetings and then conduct during public comment period. There are First Amendment considerations here. The public, if we're going to give them the opportunity to speak as a First Amendment right to speech in this limited public forum. It's a limited public forum though, meaning that we can define how it is that they are going to speak. They can't use profanity. They can't engage in speech that is unduly disruptive to the board. These are some complicated legal areas. Talk to your corporation counsel early and often when you're crafting the rules surrounding public comments. But you'll see in these board rules in this template, we've got some considerations that are tried and true considerations that courts have found to be acceptable. So this is a discussion starter, but honestly, talk to your corporation counsel about this early and often because it's really important First Amendment consideration. Board member participation at committee meetings at which they're not a member. This comes up quite often too. Under Wisconsin law, any board member is allowed to attend a committee meeting. When it comes to closed session, if you have a rule on the books that allows you to exclude that board member who's not a member of the committee from the committee meeting, then you can exclude that member. And I've seen different counties do it different ways, either with the call of the committee chair, by majority vote of the committee, whatever the case may be. But you have to have that rule on the books. Otherwise, the board member has a statutory right to be in that meeting. All right. Robert's Rules has a provision in it that suggests that you can exclude those members and you can connect the dots and say by incorporation of Robert's Rules that you have the ability to exclude that board member, and that complies with Wisconsin law. That argument is there, but I'd rather see it black and white in the board rules allowing for the exclusion. All right. But what about a board member who attends a committee meeting and wants to speak on an issue that the committee is discussing? Are they automatically allowed to speak? No, they're a member of the public at that point. Should we have a special provision that if they are recognized, they have the opportunity to speak? Yes, I think you should, because I think they may have input on a particular item that's important to the committee's deliberations. So let's have a rule on the books that speaks to this concept of board member attending a committee meeting when board member is not a member of the committee and wants to speak to an issue. It ought to be through permission, probably the committee chair. Your thought?
So we had that in Polk County where in addition to public comment, there was also a second section that said that was specifically for board members not seated as a committee member who wanted to speak on one of the topics. And it also gave discretion for the committee chair to invite that board member to participate in discussion, as long as we weren't looking at creating a quorum of another committee or something by adding that particular board member to the discussion.
Reconsideration, that's addressing Robert's rules, but this deals more with timing. When can a reconsideration motion be made? If you look at Robert's rules, it has to be in the same or a successive meeting, and it's not entirely clear in Robert's rules how that applies to county government. And so in your board rules, let's define when somebody can make a motion to reconsider. There are all sorts of procedural issues with a motion to reconsider that apply. So it may not always, even if you make it at the same or successive meeting, it may not always be in order. And that's a bit, I don't want to get into the weeds too much, but let's define when it is under typical circumstances, somebody can make the motion to reconsider. Resolutions, form and introduction. Again, I think it's good to have a fiscal note on every resolution that your administrator, administrative coordinator, finance director, somebody signs off on and says, here's the economic impact associated with this particular resolution. The other space I like is legal note. Corporation counsel doesn't want to be surprised by a resolution at a meeting. And when somebody asks the question, well, are we required by law to do something like this? You're putting corporation counsel on the spot when typically as lawyers, we want to make darn sure that the advice we're giving is correct. And so we may want to consult the statutes, case law, or something. So having the resolutions go through corporation counsel in advance, I know every corporation counsel out there, Malia, is probably pounding their head on the desk saying, why are you creating more work for me? But I think having that advance notice is probably good. Agree?
In fact, I think that it's almost necessary, especially when you're talking about anything that involves.
I just want to make sure every corporation counsel out there heard that. It wasn't Andy, it was Malia that said it's almost necessary.
Hey, they had it in the rules that the corporation counsel had to draft all resolutions. So that was even more work. We would get emails saying, I've got this idea. Can you pretty it up and put it into resolution? So I don't suggest having that, but making sure that there is a requirement that the corporation counsel at least puts eyes on that resolution before a meeting is, I think, imperative. And I stand by it.
Good. I like that. I like that. All right. Introduction of resolutions. How does something in resolution form get before the county board? Can individual members introduce resolutions? If so, what type of support is required for that individual to submit a resolution? Are we just going to allow supervisors to introduce resolutions on their own? Define that within your board rules. I typically like to see that there be some sort of support for a resolution. If we don't have at least one other signature on that resolution besides the person who's introducing it, I don't think it should get to the board floor. That means it doesn't have any support. So it's up to you to define how that process occurs. Resolutions proposed by the committee. A committee, of course, that's where the majority, at least in my experience, that's where the majority of resolutions come from, is that they come from the committee up to the board. And so do we have a process for filing that resolution, what are the signature requirements, and so on. And then we have a series of resolutions that are the feel-good resolutions, the ones that we like to make that are typically unanimous. I've seen them in certain counties not be unanimous, but nonetheless, they're typically unanimous, commemorating people for their service to the county and so on. And so if we want to have a rule in place that says, look, we're not going to commemorate somebody's retirement unless they file their official paperwork with ETF saying they're retiring for WRS purposes, you can put that rule in place here, because I've seen counties be from time to time a little bit embarrassed when somebody retires from the county and then takes a job at the city the next day. So you want to consider that as well. All right, 410, suspension of an amendment to rules. And these are pulled from Robert's rules in large part. When we have our board rules in place, they're like the bylaws of the county board. And if you look at Robert's rules, they say in there that you ought to have a pretty high bar if you're going to change the rules of procedure that govern your body, your bylaws, your board rules. And so we have in this template that they can be suspended by 2/3 vote, all right, provided the suspension does not cause a violation of the statutes. What do we mean by suspension? Well, if in these board rules, we have a particular rule of procedure that, for example, says that we are not going to take up a motion to reconsider at the same meeting for this reason or that reason, and you want to suspend that rule for purposes of taking up a motion to reconsider at that meeting, then it takes a 2/3 vote of the body to suspend the rule, allowing the motion to be made in the first instance. That doesn't mean that the underlying motion requires a 2/3 vote. All right, it just requires that you have that first vote to suspend the rule that would otherwise prohibit the action that you want to take. And again, if you get 2/3 vote, then you can move on to the item of business that was otherwise prohibited under the rules of procedure. With amendment to the rules, that's a little more drastic. That's not just the temporary suspension of the rules. That means permanently we are going to amend these rules going forward. And so we want to have a supermajority vote on amendment to the rules. And the question is, and the reason it's bracketed and italicized here is, do we want to make it of the entire board, all members elect of the board, or do we want to make it to people that are just at that meeting? We know under Robert's rules that typically all you need, and under 59.02 of the statutes, all you need is a quorum there to transact official business. And so do we want to have a supermajority requirement of the entire board in order to amend those rules? I think that's a good idea. Malia, what do you think?
Absolutely, because if not, you might have just enough to hold a meeting, and they could, by 2/3 of that, less than or just over half of the members, let's say, that are there. So then you've got less than half of the actual total members voting to amend the rules, and that permanently amends the rules unless and until you go through the same process in the future.
And this gets back to the point I talked about previously, is that the Appendix A, the supplement that describes the committees, that can be amended at any time by majority vote. I think that that's a document that's probably a living, breathing document that counties every couple of years decide, hey, it doesn't make sense for this committee to do this or this committee to. So we want to probably have more flexibility in amending that sort of document. Additional rules to consider, and this is where we get into what I was speaking to earlier with the conduct, this whole issue of what is decorum, board member rules of conduct. And so do we want to put in our board rules that, hey, this is what the expectation is if you're a board supervisor, all right? Conduct at meetings, conduct outside of meetings. And then as elected representatives, how do we interact with staff within our county? How do we interact with the public and so on? And then enforcement. Do we want to have a provision for enforcement of these rules? And I'm going to give a shout out to Langley County because I know they went through some challenges with one of their particular supervisors. Gosh, this is going back a few years now, but I know that they put together an entire enforcement section for their board rules. And so what you see here in the template is borrowed in large part from Langley County. I know that's tried and true because that was a case that went all the way through the Court of Appeals. But hats off to Langley County on really putting some thought on an enforcement mechanism for the board rules. Again, you don't have to have an enforcement mechanism in your rules, but I think it's helpful. Again, setting expectations. If you violate these board rules, here's what could happen. And if you look at the enforcement, we have the ability to have law enforcement intervention here. There's this whole concept of disorderly conduct as a penalty for violating what society believes the norms of society to be. Well, the norms of a board rule are defined, or norms of a board proceeding are defined within your board rules. And so if you go outside those norms, law enforcement may have an opportunity to issue a citation for disorderly conduct. That's a thought. You can put that in there as well. And then if we look at the additional sanctions, so to speak, again, we're getting into some First Amendment issues and we're getting into some statutory issues as it relates to disciplining, so to speak, an elected board supervisor. So again, speak early and often with your corporation counsel about this, but you'll see there 1 through 6, there is almost a progression through the disciplinary measures that you can take against board supervisors, ranging from private reprimand all the way to referral to a committee to determine if cause exists to seek that board member's removal. So again, you have the opportunity to put that within your board rules, not required, but I always think it's a good idea to set those expectations. Thoughts on that, Malia?
Well, this came up in Polk County where there is an allegation that a county board supervisor violated the rules of order, but that person was no longer on the county board. There was an election, they were not reelected, and so then there was action that certain members of the ethics committee wanted to take as far as some type of censure or public reprimand, and whether or not there was any jurisdiction to do that. So depending upon whether or not you want to at least put your board members on notice that conduct that happened while they were seated board member, but that is addressed after, whether there's jurisdiction, do you think that that should be placed in the board rule or a code of ethics?
Yeah, and okay, so you bring up a good point, and question is one is a matter of jurisdiction. If you look at 1 through 6, there's nothing you can do to a former supervisor. I mean, you could censure, you could private reprimand, censure with a resolution. You could always adopt a resolution saying that that conduct was unbecoming, so to speak, of an elected official within the county. But you can't remove somebody from a committee, you can't remove a chair, you can't certainly kick them off the county board, because they're not on the county board anymore. And so maybe addressing that within the board rules would be appropriate. I don't know how you'd address it in the board rules though, because it's almost a case by case determination that can get a little bit challenging. The second thing I just wanted to point out is that don't confuse decorum with ethics. Ethics relate to, if you look at 19.59 of the statutes in your local ethics code, it's always going to relate back to the money. There's always going to be a monetary issue associated with an ethics charge. Decorum has nothing to do with money. And so you want to make sure you separate ethics issues from decorum issues. And if you've got misconduct in the sense of decorum under the board rules, treat that as misconduct under your board rules. Don't refer it to your ethics committee because they're not equipped to deal with that under your ethics code or the state ethics code. Same holds true for ethics issues. Deal with it as an ethics issue and not a decorum issue on your board rules. And you'll see in here, I think we have language that say if it's an ethics issue, yeah, if it's an ethics issue that we identify, there's going to be a referral to the ethics committee. You're not going to deal with that as an issue under the board rules. So yeah, you got to make sure, because I think a lot of people get confused and say, well, so-and-so was a jerk at the meeting, he was unethical. Well, okay, that's not really the same thing. And I think there's confusion about terminology. So make sure that we separate ethics issues from decorum issues within our board rules. Tracy asked a question, and Tracy's good at this stuff. She's very detail oriented. Can you send the template out again? I printed it off and it doesn't include the last pages. Thank you, Tracy, for the reminder, because you're right. We just added this supplement here very recently. So we will get the template back out to folks with this additional, these additional rules for consideration. So look that out, Tracy. And Conley just echoed Tracy's comments. So we are at the 12:56 mark, and it's Thanksgiving week, so I know everybody's eager to get on with their plans for the week. But Malia and I will be here for the next 5 minutes to make sure that any questions or comments you have are addressed. Let me end by saying this. It is Thanksgiving week, so I'm thankful, and I know Malia is too, that all of you are serving local government throughout the state of Wisconsin in a wonderful way. And so we thank you for your service to county government, and we're thankful that we get to consider all of you to be friends, colleagues, clients, and so on throughout the community. So thank you. With that, Sarah, anything that you wanted to add that we may have overlooked, or your thoughts on further comments and so on as we wait for some questions to come in?
I do not have any further thoughts or comments on this presentation. David, I know you have your hand raised. We're not set up though to to take questions verbally on this webinar. Is it possible for you to put your question in either the chat or the Q&A? That would be the best way to do that, to ask your
You
question.
said it was inadvertent. And you know,
Inadvertent. Okay. It's popped
so
up a couple of times.
I'm call Dave out specifically and say happy Thanksgiving, Dave.
That's right. That's right. Otherwise, I am not seeing any additional questions or comments at this time, other than thanks to you guys and happy Thanksgiving to all. While we wait to see if any other additional questions pop up, I do want to mention that we are back in 3 weeks. Yes, only 3 weeks instead of 4 this time, with our December in the boardroom, which will be held on Wednesday, December 18th at noon, on the topic of town withdrawal from county zoning. That's going to be a fun topic, Andy.
Is it really the holiday season on a high note, talking about town withdrawal from county zoning? Is that what we're doing? We set that up well, didn't we?
Yeah. And just
I think we ought to have an in the boardroom on how to make sure that your kids do adequate preparation activities for Thanksgiving. How do we do that, Sarah? It's not a legal topic, but I think it'd be a good discussion.
How your kids, yeah, sure. That'd be great.
I think that'd be awesome.
Or how to train your husband how to properly clean the house prior to holidays.
Going down the road that I don't want to go down. I
You don't
don't have,
want to talk about that one?
no, I'd rather talk about my kids helping out.
Yeah, I've got both those issues. So hey, I come into the office for 2 hours. I'm curious what my house looks like when I get back.
There you go.
Yeah, so and I should mention as well, we do have the date set for 2025. So I guess this is our official announcement that this series will be continuing into next year as well. So in the next few weeks or so, we will get out the information. Actually, by next week, we'll get out the information on the December in the boardroom. And then following that, we will get everybody the dates for 2025. I can't believe it's going to be 2025 already. So that you can get those on your calendars.
Awesome. Happy Thanksgiving, everybody. It's been a pleasure. And if you have any questions about orders, seriously, this is something a lot of counties are going through right now. Sarah is an awesome resource. We're happy to help wherever we can. And so we want to make sure that counties are running as efficiently as possible without frustration. So whatever we can do to help, let us know how we can help.
Absolutely.
Awesome. Thank you so much. And I guess we will see everybody on December 18th.
All right. Happy Thanksgiving.